Today, I'm breaking down 5 common lease terms I see all the time that are actually illegal. My name is Zachary Soccio-Marandola. I'm a real estate lawyer here in Toronto, and I help people like you close real estate deals every single day. Before we dive into the 5 clauses, there's one very important rule that you need to know. An illegal clause in a lease does not make the entire agreement void. It only makes that specific clause unenforceable. Now, with that in mind, here are the 5 clauses that I regularly see that don't actually hold up. Number 1 is no pets. This is probably the most well-known one here, but I still see it in leases all the time. So a lease agreement in Ontario cannot prohibit a tenant from having pets. The RTA even went as far as adding a very specific provision that flat out says no pets provisions are void. This one couldn't be any more clear. Now, that being said, a landlord is allowed to ask about pets at the application stage, and a tenant's answer can contribute to a decision not to rent to someone. Also, if a pet is in the unit and causes damage, excessive noise, or safety issues, that can create grounds for eviction. But once that tenancy exists, a blanket no pets clause in the lease cannot be enforced. There is an exception for condos. If the condominium corporation has a rule or bylaws that restrict pets, and that can be the size, the number of, or the type, then the landlord can in fact enforce those rules through the lease, but they have to come from the condo corporation first. Number 2 is no roommates. This one catches a lot of people off guard, but a landlord cannot add a clause that prohibits a tenant from having roommates, friends, partners, or spouse move in. These people are generally considered guests or occupants and not tenants, so long as they didn't sign the lease. Now, the original tenant remains fully responsible for rent, damage, and behavior, but the landlord cannot block the arrangement and cannot charge extra rent or fees just because someone else moved in. This is all provided that the unit is not overcrowded and municipal occupancy standards are met. Now, the key distinction is that guests and occupants don't gain independent tenant rights against the landlord. If the original tenancy is terminated, then the guest or occupant has to leave too. If they don't, they can be treated as an unauthorized occupant and the landlord can apply to evict them. Number 3 is making the tenant responsible for grass and snow maintenance. This one gets confusing because the rules change depending on the type of property. So if you're dealing with a single family home that's rented entirely to one tenant or family, and they have exclusive use over everything, that would be the driveway, the front yard, and the backyard, then the tenant can be made responsible for things like lawn care and snow removal through the lease agreement. Once a property has common areas, this whole analysis changes. So think about apartment buildings, duplexes, or even single-family homes with an upper and lower unit. Now, the driveway, the front yard, and the backyard are shared spaces. And under the RTA, exterior maintenance of a common area is the landlord's responsibility. In those situations, a clause in the lease that tries to shift lawn care or snow removal to the tenant is unenforceable. There is a commonly used workaround. So if a tenant actually wants to handle the lawn care or snow removal, the landlord and tenant can enter into a separate contract for those services, but it has to be completely separate from the lease. And the tenancy cannot depend on that agreement at all, so it can't be buried in the lease, or it can't be a condition of renting the unit. Number 4 is having the tenant pay a repair deductible. So this one often is written like this. The tenant agrees to pay the first $100 of any repairs. This kind of clause is illegal. Under the RTA, landlords are responsible for maintaining the unit and keeping it in good repair. And that includes things like appliances, plumbing, heating. So a landlord cannot shift the routine maintenance costs onto the tenant by adding a deductible or minimum repair amount into the lease, even if the tenant agrees to it. But, and this part really matters, tenants are fully responsible for damage that they or their guests cause, whether that's intentional or due to negligence. And that's not maintenance, that's damage. And landlords can recover the cost of damage through the proper legal process. Number 5 is fixed-term leases that require vacant possession at the end. So here's an example of one I came across recently. It says, this tenancy is for a fixed term. If the lease is not renewed, the tenant agrees to vacate immediately and pay any losses caused by failing to do so. This entire concept is wrong. In Ontario, when a fixed-term lease ends, it automatically converts to a monthly tenancy on the same terms. The tenant does not have to leave, and they do not have to sign a renewal. And a landlord cannot contract out of that rule. Any clause that says a tenant must vacate simply because the fixed term ended is void. And once that part is void, the follow-up language about paying costs or losses for not vacating is also unenforceable. Now, a landlord and tenant can mutually agree to end a tenancy after it's already begun, but that kind of promise cannot be a condition of entering into the lease. A landlord can only end a tenancy for reasons permitted under the RTA and only by serving proper notice and, if necessary, going to the landlord and tenant board. You cannot skip this process with clever drafting. So let's end with a few tips that you can use if you find an illegal clause in your lease. First, remember that it does not give a tenant the right to stop paying rent. So if you're a tenant, don't hurt your own legal position by withholding payment. And if you're a landlord, having an unenforceable lease term doesn't affect your entitlement to collect rent. It just means you can't enforce that specific clause. Second, if the relationship is functional, the best starting point is usually to raise the issue and that point of law. Many illegal clauses stay in leases simply because they've been copy and pasted for years, and more often than not, the drafting party is actually just not aware that that clause is unenforceable. Finally, before taking steps to escalate the situation, always speak to a licensed paralegal or lawyer to get a clear understanding of your rights for that specific situation. If you found this video helpful, subscribe to the channel here for more practical real estate law content. Thanks for watching.